This is the second of 2 tapes on the text of the Constitution, and the 6th in an 8-tape series on the U.S. Constitution.
When Americans think of the Supreme Court, they often associate it with the power of judicial review, that is, the power to nullify laws by declaring them unconstitutional. This power, however, is not found in the Constitution. According to some legal scholars, the power of judicial review, even if it is not expressly granted by the Constitution, is at least implied by some of its provisions. Other legal scholars disagree. It is difficult to settle this controversy by referring to the Constitutional Convention. Convention delegates did not spend much time discussing specific powers of the federal judiciary. Some delegates seem to have favored a Supreme Court with a power of judicial review, while other delegates seem to have opposed the idea. The Virginia plan, on which much of the Constitution is based, originally included a provision which hinted at judicial review. The Virginia plan called for a council of revision consisting of the President and members of the federal judiciary. This council would judge whether state laws conform to the Constitution, and it would be empowered to nullify state laws by declaring them unconstitutional. The proposed council of revision was seen as a serious threat to state sovereignty, and it was voted down. In its place, small state delegates proposed a resolution which, when included in Article 6 of the Constitution, has become known as the Supremacy Clause. This clause, after declaring the Constitution to be the supreme law of the land, goes on to say,
"The judges in every state shall be bound thereby, anything in the Constitution or laws of any state to the contrary notwithstanding."
Notice how this passage refers to state courts, not to federal courts. During the Constitutional Convention, the Supremacy Clause was offered by advocates of state sovereignty as a compromise with nationalists. The Constitution was to be supreme, but the Supremacy Clause left open the possibility that state courts would decide on the constitutionality of laws. This interpretation, had it been accepted, would have left the states with considerable power. State Supreme Courts had long exercised the power of judicial review over the laws of their own states. Now it looked as if these state courts would judge the constitutionality of federal laws as well. If this was a victory for defenders of state sovereignty, their victory was fairly short-lived. Article 1, Section 8 of the Constitution empowers Congress to constitute tribunals inferior to the Supreme Court, and this is exactly what Congress did a year after the Constitution was ratified, in the famous Judiciary Act of 1789. The Judiciary Act structured the federal judiciary more or less as we know it today. It established a 3-tiered system of federal courts, the district, circuit, and Supreme Courts. And in Section 25, the Judiciary Act allowed Americans to appeal some decisions from state courts to the Supreme Court, if constitutional issues were involved. Now, this was the first major step in vesting the federal Supreme Court with the power of judicial review. The Judiciary Act rendered state courts subordinate to federal courts in a manner not expressly stated in the Constitution. During its early years, the Supreme Court sometimes issued decisions which implied the power of judicial review. In those years, however, the Supreme Court had 6 justices, and each justice delivered a separate opinion. Thus, there was no dominant voice or majority decision in which the power of judicial review could germinate and grow. All this changed after John Marshall was appointed Chief Justice in 1801. Marshall inaugurated the practice of issuing a majority decision, thus allowing the Supreme Court to speak with a unified and powerful voice. And in 1803, in the complex and controversial case of Marbury versus Madison, Chief Justice Marshall forever embedded judicial review into American law. Marshall mapped out 2 possibilities. Either the Constitution is the fundamental law of the land, or it is not.
Between these alternatives, there is no middle ground. The Constitution is either a superior paramount law, unchangeable by ordinary means, or it is on a level with ordinary legislative acts, and like other acts, is alterable when the legislature shall please to alter it. If the former part of the alternative be true, then a legislative act contrary to the Constitution is not law. If the latter part be true, then written constitutions are absurd attempts on the part of the people to limit a power in its own nature illimitable.
The purpose of a written constitution, declared Marshall, is to establish fundamental and supreme laws. Clearly, this means that any legislative act contrary to the Constitution is void and without effect. What, then, should the Supreme Court do when confronted with an unconstitutional law?
It is emphatically the province and duty of the Judicial Department to say what the law is. Those who apply the rule to particular cases must of necessity expound and interpret that rule. If two laws conflict with each other, the court must decide on the operation of each.
According to Marshall, the power of judicial review is implicitly contained in the United States Constitution.
The judicial power of the United States is extended to all cases arising under the Constitution. Could it be the intention of those who gave this power to say that in using it, the Constitution should not be looked into? That a case arising under the Constitution should be decided without examining the instrument under which it arises? This is too extravagant to be maintained. In some cases, then, the Constitution must be looked into by the judges. And if they can open it at all, what part of it are they forbidden to read or to obey?
Marshall stated his conclusion with force and clarity.
Thus the particular phraseology of the Constitution of the United States confirms and strengthens the principle, supposed to be essential to all written constitutions, that a law repugnant to the Constitution is void, and that courts, as well as other departments, are bound by that instrument.
John Marshall's decision in Marbury v. Madison is the cornerstone of judicial review by the Supreme Court. And Marbury v. Madison, we should note, was a case fraught with political implications. In 1800, Thomas Jefferson defeated John Adams for the presidency, and Jefferson's party won control of the Congress. Before Jefferson took office in 1801, however, his political opponents tried to solidify their control of the judiciary. They passed the Judiciary Act in 1801, which created new federal judgeships, and then Adams packed these positions with party loyalists. In addition to these midnight appointments, as they were called, this Judiciary Act also reduced the number of Supreme Court justices from 6 to 5. This was to lessen the possibility of Jefferson appointing a justice during his presidency. Finally, and most importantly, Adams appointed his Secretary of State, John Marshall, to the position of Chief Justice of the Supreme Court. The landmark case of Marbury v. Madison arose from this political struggle to control the federal judiciary. Did John Marshall act as an impartial, objective judge, or did John Marshall act as a political partisan who wished to strengthen a federal judiciary filled with opponents of Thomas Jefferson? As always, historians disagree. Historical mind-reading is at best a hazardous enterprise. But for the record, we should note that John Marshall, the champion of judicial review, seemed to have entertained different views in his earlier years. In 1788, a 33-year-old John Marshall served as a member of the Virginia Ratifying Convention. In defending the proposed Constitution, Marshall tried to reassure critics that the federal judiciary would not encroach on state sovereignty.
In disputes between a state and the citizens of another state, I hope that no gentleman will think that a state will be called at the bar of a federal court. It is not rational to suppose that the sovereign power of a state should be dragged before a court.
In 1790, shortly after the Constitution had been ratified, there were approximately 700,000 slaves in the United States, almost 20% of America's total population. By 1860, the number of slaves had swollen to 4 million. In 1865, the 13th Amendment to the Constitution abolished slavery in America.
Neither slavery nor involuntary servitude, except as punishment for crime whereof the party shall have been duly convicted, shall exist within the United States, or any place subject to their jurisdiction.
During the 1840s and 50s, many anti-slavery radicals, or abolitionists as they were called, pointed an accusing finger at the Constitution. The Constitution, they argue, while supposedly a citadel of liberty, actually supported the hideous institution of slavery. John Quincy Adams, 6th President of the United States, put the matter bluntly.
Yes, it cannot be denied. The slave-holding lords of the South prescribed, as a condition to their assent to the Constitution, 3 special provisions to secure the perpetuity of their dominion over their slaves. The first was the immunity for 20 years of preserving the African slave trade. The second was the stipulation to surrender fugitive slaves, an engagement positively prohibited by the laws of God. And thirdly, the exaction, fatal to the principles of popular representation, of a representation for slaves, for articles of merchandise under the name of persons. In fact, the oppressor representing the oppressed. To call government thus constituted a democracy is to insult the understanding of mankind.
Although the words slave and slavery never appear in the Constitution, 10 clauses support it, directly or indirectly. We shall focus on the most important of these. The first reference to slavery is the 3rd clause of Article 1, Section 2. Here slaves are discreetly referred to as all other persons.
Article 1, Section 2. Representatives and direct taxes shall be apportioned among the several states which may be included within this Union, according to their respective numbers, which shall be determined by adding to the whole number of free persons, including those bound to service for a term of years, and excluding Indians not taxed, 3/5 of all other persons.
This is the famous 3/5 rule, whereby a slave was counted as 3/5 of a person when calculating the number of representatives allotted to states. After stating this rule, the Constitution demands that a census be taken every 10 years in order to assign the proper number of representatives.
Article 1, Section 2. The actual enumeration shall be made within 3 years after the first meeting of the Congress of the United States, and within every subsequent term of 10 years, in such manner as they shall by law direct.
Thus, when a census was taken, 5 slaves were counted as the equivalent of 3 persons for the purpose of assigning representatives. This 3/5 rule increased the power of slave states in the House of Representatives, and so was to play a major role in American politics until the Civil War. The 3/5 rule was familiar to convention delegates. Known as the federal ratio, it had been used since 1783 to apportion taxes among states. The federal ratio of 3/5 was included in the Constitution as part of complicated negotiations and compromises over proportional representation, that is, representation based on population. Large states desired proportional representation in both branches of the national legislature. Small states, fearing domination by their larger neighbors, desired equal representation for all states in both branches. This was the most significant conflict during the Constitutional Convention, and it finally was resolved on July 16th in what is known as the Great Compromise. This agreement called for proportional representation in the House of Representatives and for equal representation of states in the Senate.
Article 1, Section 2. Representatives and direct taxes shall be apportioned among the several states which may be included in this Union, according to their respective numbers. Article 1, Section 3. The Senate of the United States shall be composed of 2 senators from each state, chosen by the legislature thereof, for 6 years, and each senator shall have 1 vote.
For many delegates, the clash of interest between big states and small states loomed as the most significant problem confronting the future of America. But James Madison disagreed. On the 14th of July, while the convention was debating representation in the Senate, Madison rose to defend proportional representation. The real conflict facing America, he prophetically asserted, was not between large states and small states. Rather, the conflict was between northern states and southern states. The dividing line, Madison declared, was slavery.
It seems now to be pretty well understood that the real difference of interest lays not between the large and the small, but between the northern and southern states. The institution of slavery and its consequences form the line of discrimination. There are 5 states on the southern, 8 on the northern side of the line. Should a proportional representation take place, it is true the northern would still outnumber the other, but not in the same degree at this time, and every day would tend towards an equilibrium.
James Madison, though a slave owner, was philosophically opposed to slavery. This caused him some embarrassment when he defended the 3/5 rule in the Federalist Papers. There Madison placed quotation marks around his defense of the 3/5 rule. He then went on to say,
Such is the reasoning which an advocate for the Southern interests might employ on this subject, and although it may appear to be a little strained in some points, yet, on the whole, I must confess that it fully reconciles me to the scale of representation which the Convention have established.
Like other slavery provisions in the Constitution, the 3/5 rule was required to bring the Deep South into the American Union. As Madison put it in a letter to Thomas Jefferson, South Carolina and Georgia were inflexible on the point of slaves. Early in the Constitutional Convention, Pennsylvania's James Wilson proposed a compromise on slavery and representation. He suggested incorporating the 3/5 rule in the Constitution. Weeks later, however, Wilson had second thoughts.
I do not well see on what principle the admission of blacks in the proportion of 3/5 can be explained. Are they admitted as citizens? Then why are they not admitted on an equality with white citizens? Are they admitted as property? Then why is not other property admitted into the computation? These are difficulties, however, which I think must be overruled by the necessity of compromise.
Wilson, like many delegates, was philosophically opposed to slavery, but he was not free of the racism endemic in 18th century America. One of Wilson's arguments against the 3/5 rule displays an attitude that, unfortunately, was common among delegates. White Americans, Wilson contended, would object to being included in the same census with blacks.
I have some apprehensions also from the tendency of the blending of the blacks with the whites to give disgust to the people of Pennsylvania, as has been intimated by my colleague, Mr. Gouverneur Morris.
Pennsylvania's Gouverneur Morris had indeed protested the 3/5 rule because white citizens would object to being classified with blacks. It is to Morris's credit, however, that he delivered the convention's most vitriolic attack on slavery.
I will never concur in upholding domestic slavery. It is a nefarious institution. It is the curse of heaven on the states where it prevails. Upon what principle is it that the slave shall be computed in the representation? Are they men? Then make them citizens and let them vote. Are they property? Why, then, is no other property included? The houses in Philadelphia are worth more than all the wretched slaves who cover the rice swamps of South Carolina. The admission of slaves into the representation, when fairly explained, comes to this: that the inhabitant of Georgia and South Carolina, who goes to the coast of Africa, and in defiance of the most sacred laws of humanity, tears away his fellow creatures from their dearest connections, and damns them to the most cruel bondage, shall have more votes in a government instituted for the protection of the rights of mankind than the citizen of Pennsylvania or New Jersey, who views with a laudable horror so nefarious a practice.
Some Southern delegates demanded that slaves be counted as full persons when computing representation. As South Carolina's Charles Pinckney put it,
I move to make blacks equal to whites in the ratio of representation. This is nothing more than justice. The blacks are the laborers, the peasants of the southern states. They are as productive of pecuniary resources as those of the northern states. They add equally to the wealth, and considering money as the sinew of war, to the strength of the nation.
This proposal would never fly in the convention. Pro-slavery delegates would have to compromise. But the federal ratio was their bottom line. North Carolina's William Davie issued the ultimatum: include the 3/5 rule or forget about support from the Deep South for a new constitution.
It is high time to speak out. Some gentlemen mean to deprive the southern states of any share of representation for their blacks. I am sure that North Carolina will never confederate on any terms that do not rate them at least as 3/5. If the eastern states mean, therefore, to exclude them altogether, The business is at an end.
Thus slavery, that peculiar institution, as Americans euphemistically called it, was embedded in the United States Constitution. This was the price paid for an American Union. But the slavery compromise did not end with the 3/5 rule. The power to tax, it has been said, is the power to destroy. If the federal government had been empowered to levy special taxes on slaves, the future of the peculiar institution might have been jeopardized. This concern of pro-slavery delegates generated a clause in Article 1, Section 9 of the Constitution.
Article 1, Section 9. No capitation or other direct tax shall be laid unless in proportion to the census or enumeration herein before directed to be taken.
This provision ties direct taxes to the census taken every decade. The word capitation means numbering or assessing by the head. A capitation tax, also known as a poll tax, might have enabled the federal government to cripple slavery through special taxes on slaves. Therefore, in linking capitation and other direct taxes to the census, where slaves were counted as 3/5 of a person, slave owners were assured that taxes on slaves would be limited to this ratio. Pro-slavery delegates were concerned about the slave trade. Would the Constitution prohibit the importation of new slaves from Africa? This subject provoked spirited debate during the Constitutional Convention. A preliminary version of the Constitution, reported by the Committee of Detail on August 6th, placed no restraints on the slave trade, and it prohibited the federal government from taxing imported slaves. When these provisions were debated over 2 weeks later, Maryland's Attorney General Luther Martin spoke out against the slave trade.
It is inconsistent with the principles of the Revolution and dishonorable to the American character to allow the slave trade in the Constitution.
South Carolina's John Rutledge was not interested in this moralizing.
Religion and humanity have nothing to do with this question. Interest alone is the governing principle with nations. The true question at present is whether the Southern states shall or shall not be parties to the Union. The people of North Carolina, South Carolina, and Georgia will never be such fools as to give up so important an interest.
George Mason, like James Madison, George Washington, and other delegates from the Upper South, was a peculiar critic of the peculiar institution. Mason was a slave owner who opposed slavery. He wanted a constitutional ban on the detested slave trade.
Every master of slaves is born a petty tyrant. They bring the judgment of heaven on a country. As nations cannot be rewarded or punished in the next world, they must be in this. By an inevitable chain of causes and effects, Providence punishes national sins by national calamities. I lament that some of our Eastern brethren have, from a lust of gain, embarked in this nefarious traffic. As to the states being in possession of the right to import, this is the case with many other rights now to be properly given up. I hold it essential in every point of view that the general government should have power to prevent the increase of slavery.
Connecticut's Oliver Ellsworth, the future Chief Justice of the Supreme Court, pointed out the dilemma in this argument. If the slave trade should be prohibited on moral grounds, then domestic slavery should be banned for the same reason. And, as Ellsworth well knew, no delegate was sufficiently removed from the real world of politics to call for the complete abolition of slavery.
I have never owned a slave, so I cannot judge of the effects of slavery on character. However, if slavery is to be considered in a moral light, we ought to go further and free those slaves already in the country.
When delegates from the Upper South called for banning the slave trade, Ellsworth scented hypocrisy. The economy of the Upper South, he pointed out, did not require newly imported slaves. The economy of the Deep South, however, required their continued importation. Why? Because in the Deep South, harsh conditions killed off slaves rapidly.
As slaves multiply so fast in Virginia and Maryland, it is cheaper to raise than import them, whilst in the sickly rice swamps, Foreign supplies are necessary. If we ban the slave trade, we shall be unjust towards South Carolina and Georgia. Let us not intermeddle.
Ellsworth, like many delegates, soothed his conscience with the belief that American slavery was a doomed institution.
As population increases, poor laborers will be so plentiful as to render slaves useless. Slavery in time will not be a speck in our country. Provision is already made in Connecticut for abolishing it, and the abolition has already taken place in Massachusetts.
South Carolina's Charles Cotesworth Pinckney, elder second cousin of another delegate named Charles Pinckney, injected more economic realism into this debate.
South Carolina and Georgia cannot do without slaves. As to Virginia, she will gain by stopping the importations. Her slaves will rise in value, and she has more than she wants. It would be unequal to require South Carolina and Georgia to confederate on such unequal terms. In addition, the importation of slaves will be for the interest of the whole Union. The more slaves, the more produce to employ the carrying trade, the more consumption also, and the more of this, the more revenue for the common treasury.
The outcome of these debates is contained in Article 1, Section 9 of the Constitution. This clause prohibits the federal government from interfering in the slave trade for 20 years.
Article 1, Section 9. The migration or importation of such persons as any of the states now existing shall think proper to admit shall not be prohibited by the Congress prior to the year 1808. But a tax or duty may be imposed on such importations, not exceeding $10 for each person.
The use of the word migration in this passage is surely the greatest understatement in the Constitution. History has yet to record a single instance of an African who migrated to America to sign up as a slave. Language aside, however, the slave trade provision allowed pro-slavery delegates to return home and claim victory. They had secured a 20-year guarantee of non-interference by the federal government, and they got a bonus to boot. Article 5 authorizes amendments to the Constitution, but it contains important exceptions.
Provided that no amendment which may be made prior to the year 1808 shall in any manner affect the first and fourth clauses in the 9th section of the first article.
The clauses referred to here are the 20-year sanction of the slave trade and the previously mentioned capitation tax on slaves. These provisions were sheltered from change for 20 years. No other provisions in the Constitution received this immunity. As expected, critics of the Constitution pounced on his 20-year sanction of the slave trade. One of them asked,
"In a serious hour, and in the presence of the Governor of the universe, what reasonable excuse can be made for permitting, and that constitutionally, depredations on a distant and inoffensive people for the term of 20 years?
Anti-slavery defenders of the Constitution made the best of a bad situation. After 20 years, they argued, the slave trade probably would be banned, as James Madison wrote in the Federalist Papers.
It ought to be considered as a great point gained in favor of humanity that a period of 20 years may terminate forever within these states, a traffic which has so long and so loudly upbraided the barbarism of modern policy, that within that period it will receive a considerable discouragement from the federal government, and may be totally abolished by a concurrence of the few states which continue the unnatural traffic in the prohibitory example which has been given by so great a majority of the Union. Happy would it be for the unfortunate Africans if an equal prospect lay before them of being redeemed from the oppressions of their European brethren."
Madison got his wish. In 1808, Congress banned the slave trade, but domestic slavery lived on in America for another half-century, and another major provision in the Constitution buttressed the institution.
Article 4, Section 2. No person held to service or labor in one state, under the laws thereof, escaping into another, shall, in consequence of any law or regulation therein, be discharged from such service or labor, but shall be delivered up on claim of the party to whom such service or labor may be due.
This passage, known as the Fugitive Slave Clause, demanded the return of escaped slaves to their owners. More than any other part of the Constitution, this clause provoked the wrath of anti-slavery abolitionists during the mid-19th century. Why? Because according to the Fugitive Slave Clause, even free states were required to participate in the enforcement of slavery by returning runaway slaves. Henry David Thoreau protested the Fugitive Slave Clause in his famous essay on civil disobedience. The famous abolitionist William Lloyd Garrison had this clause foremost in mind when he assailed the Constitution as a covenant with death and an agreement with hell. If we wish to appreciate the historical importance of the Fugitive Slave Clause, we need only remember the infamous case of Dred Scott, decided by the Supreme Court in 1857. In this decision, Chief Justice Taney declared,
"There are two clauses in the Constitution which point directly and specifically to the Negro race as a separate class of persons, and show clearly that they were not regarded as a portion of the people or citizens of the government then formed."
Chief Justice Taney cited the Slave Trade Clause and the Fugitive Slave Clause. With these as his constitutional pillars, Taney supported one of the most despised conclusions in the history of the Supreme Court. Black Americans, he declared, were not entitled to the protection afforded to citizens of the United States.
These two provisions show conclusively that neither the description of persons therein referred to, nor their descendants, were embraced in any of the other provisions of the Constitution. For certainly these two clauses were not intended to confer on them or their posterity the blessings of liberty, or any of the personal rights so carefully provided for the citizen.
This is the end of Side 1. Please fast forward and turn over your cassette.